everyone. In this video, I want to talk about 3 things that you need to know in order to pass NCA Administrative Law exam. The first thing I would like to do is touch upon some of the key concepts that you should be aware of when you're preparing for this exam. The second thing I want to talk about is the Vavilov Supreme Court of Canada decision, which drastically changes the standard of review analysis. And I'm going to point towards another resource that you can use, which will really help you clarify the concepts. And the last thing I'm going to do is I'm going to share my screen and I'm going to share a question that I've written myself. And I will walk you through my thought process on answering that question. So if you're interested, keep watching. The thing I want to touch upon is some of the key concepts that you should know when you're studying for this exam. So first of all, you want to understand, what does admin law really do? So admin law operates the way the government works. So it makes sure that the government is acting in a way which is in accordance with the power granted to the government by the statute. So it is using the power granted to it properly and in a fair manner. Now, in doing so, there are certain concepts that you should always be clear of. So first of all, when you see a question and you see a decision, you want to make sure that, if you see a government decision on an exam, you will always want to question whether the government made this decision adopting procedures that were fair. So remember when I said that admin law governs the way the government operates? So it does so by making sure that, first of all, the procedure that the government is adopting is fair. Now, again, procedural fairness is a big topic on your syllabus, which talks about common law duty of procedural fairness and then triggers. So you want to know all the detail, but again, I'm just pointing out that this is an area which is very important. So again, whether the procedure adopted by the government was fair, and fair is a term that you will have to define in terms of doing the entire analysis. The second thing is that you want to make sure that you understand that whether the substance of the decision, so when I say substance, what I really mean is the decision itself, like is it reasonable or is it correct, depending on the standard of review. Again, standard of review is another analysis that you have to do, but this is like the bigger picture that I'm talking about. And the last key concept is whether the decision infringes any charter. So again, remember, admin law operates, it governs the way the government operates. And how does it do that? By making sure that the procedure is fair, the decision is reasonable or correct, depending on the standard of review, and then whether the decision infringes the charter. So again, these are important concepts, which again, are lengthy concepts. You need to understand them, but just remember that you might be tested on these concepts on the exam. The thing I want to talk about is the Vavilov Supreme Court of Canada decision. I'm not going to go into too much detail, but I would like to point you guys towards a resource that I have already mentioned. So if you haven't watched my video, take a look at 5 free NCA resources that I mentioned. I spoke about Craig Forsey's podcast, so I noticed that he had uploaded new podcasts talking about the Vavilov decision. So if you haven't watched it, you're probably at a great loss. So you should really just go watch them as soon as hear them. Actually, hear the podcast as soon as possible. But in a nutshell, again, I'm going to be using very simple words to explain that Vavilov is a decision that changes the standard of review analysis. So remember, I talked about the substance of the decision, and you can only analyze the decision itself, by, first of all, understanding what the standard of review is. So back in the day, when we had to determine a standard review, we had to take a look at different factors, we had to look at previous decisions, and there was a different analysis back in the day. But now, and it is important that you use the Vavilov decision, because that's what your syllabus tells you, that you need to use that decision or else you won't get any marks. So what the decision says is that there is a presumption that the standard of review will always be reasonableness. So the starting point is that reasonable is the standard, but that presumption can be rebutted. Rebut means that you don't have to follow. You can change that if, for instance, and then the decision lists down certain factors. So, for instance, one of the factors is that if the statute says that the standard is correctness. So, always remember that when you are conducting the standard review analysis, now the presumption is that it's reasonableness. However, you can rebut the presumption if, for example, if the statute tells you to do so. And then again, there are more factors that you should be reading yourself. I'm only giving you very, very basic idea. So remember, the presumption is reasonableness, and again, you can rebut the presumption by taking a look at the decision. There are certain factors that are mentioned there, and don't forget to actually listen to Craig Forsey's podcasts. Share my screen. I will share a question that I had drafted, and now I'm going to walk you through the thought process. The question I drafted is a bit long, so you should, if you want, you could pause the video and read it, or whatever way you like it. Just do whatever makes most sense to you.
So on the left-hand side, I have this sample question that I have drafted myself. So it is my own work, and you can pause the video if you want because this is a long question. It also has another page, so you can pause it and read page 1 of this, and then I'm going to go to page 2 so that you're able to read it properly. Okay, so that is page 2. You can pause it and read it very carefully, and then I will let you know my thought process behind answering this question. So recently launched my website, which is lawstudykit.com, where I have sample questions and answers to some of the NCA courses. And this is a sample question that I had drafted for admin law. So if you want to take a look at it, and if you need additional help, you can definitely take a look at my website. So I hope that you're done reading this. So I'm going to walk you through some of the things that I like to do before I answer a question, which is this long, and there are a lot of facts. Now, especially in admin law, the first thing that you want to do is you should highlight any provisions in the question. So over here, you can see that there's section 5 of the Actuaries Professions Act that I've made up. So this question is pretty much made up. There are no real, I hope that there are no real acts like that. But so the first thing that you want to do is first of all highlight the statute. Remember I told you that in admin law we want to make sure that the power granted to the decision makers, they use that power accordingly. So the reason why I'm asking you to highlight the statute is that, the statute is going to tell you a bit about, okay, what is it that needs to be done? Okay, once you do that, you also then want to highlight what is the decision made by, whatever the body in question is. So over here, um, this is the reasons for the decision that is made, which is not in favor of Amanda. Again, just read the question before you hear what I'm saying. Okay, so first of all, you read a question, and again, this question is asking you for all possible options. So there are a lot of options that we could consider. But again, you want to make sure that you read the question and see what the examiner is asking you for. Is the examiner asking you to talk about procedural fairness, or is the examiner asking you to talk about the substantive review? Okay, so again, read the question very properly. Now, the first thing that you want to do is always, whenever we're conducting, whenever we are looking at an admin law question, first of all, we want to see is that Does the statute provide us with any right of appeal? Okay, so right of appeal. What that means is that, before we go to, challenge the decision based on procedure fairness or a substantive review, we need to first of all take a look at the statute and see, can we appeal the decision that has been made, in this case, by the institution, the Canadian Institution of Actuaries. So first of all, we want to take a look at that. Again, read the facts and see if there is a right of appeal. If there is no right of appeal, then we move on to the next steps. If we are looking at the next step is, okay, let's talk about procedural. Again, this is the way that I think. You can think it a different way, which is completely fine. Again, this is just my personal opinion, and this is how I answered the question on my exam too when I passed the exam on my first attempt. So, procedural fairness. Whenever we talk about procedural fairness, what we're trying to say is that, in this case, was Amanda given a way which was fair, in the sense that, was Amanda entitled to procedures which was fair? Now, in this case, we do see that Amanda was told that she's going to have an oral hearing, but, she didn't. So, maybe this is something that you want to discuss in this case. Also, remember that when we're talking about procedural fairness, before you go on to the common law procedure fairness, always look at statute to see if the statute talks about any procedural fairness details, or does the statute say anything in terms of what kind of procedures should the institute adopt. So always look at the statute. So procedural fairness, then we go so again, in this question, I see particularly that, she was entitled to an oral hearing, but again, she did not get an oral hearing. So that is one of the points that you can actually discuss and maybe elaborate on. Okay. Now, again, in procedure fairness, there are a whole bunch of tests that you need to know. You need to understand common law triggers, the content of procedure fairness. Again, that's something that you can read on in your notes or in the book. I'm just obviously going to give you an overview. So again, first of all, always look for in the question, is there a right of appeal? If yes, great. I'm sure that it is likely that you're not going to have a right of appeal. But even if you do, you should obviously mention that. Now, procedural fairness, we talked about procedural fairness, you have to do the entire analysis. So I'm assuming that you would know how to do the analysis here. Now, then we move on to the substance of the decision. Okay? Again, remember, I am doing all of this because this question is asking me for everything, but maybe you can get a question where they're just asking for procedural issues or they're substantive issues. Now, substantive issue. So substantive issue, like I mentioned before, first of all, you determine the standard of review. And then, again, now we're going to be using okay, what is that? Vavilov. It's just a very so yeah, the Vavilov decision that I had already mentioned. You will be using that case to determine the standard of review, and then you're going to apply the standard. So in this case, when I'm looking at the facts, I would think that the standard of review is reasonableness, because again, remember, as we said, that there is a presumption the standard of review is reasonableness, and then we could rebut the presumption, taking a look at the statute and some other reasonings that are mentioned in the Vavilov decision. So in this case, the statute does not talk about anything related to the standard review, so I would assume that, that's not the case. Also remember that it's okay, like, whenever you get facts on the exam, The facts are not always going to be black and white. You will have to assume some things, and it's okay to assume certain facts, but again, just mention them. So then you apply the standard review, and then you either decide the decision was reasonable or not, or unreasonable. Um, the decision, like, you are more than welcome to start. You're more than welcome to do your own analysis. Um, if I were to do the analysis, I would talk about some of the things that Amanda was entitled to, in terms of, like she could have, um, again, just throwing it out there, maybe she could have received some reasons as to why she didn't get an oral hearing. So that is something that you could also talk about in applying the reasonable standards. As we know from the Vavilov decision, this is something that now we should consider. Okay. So yeah, so again, remember, these again, admin law is pretty much this: procedure, substance, and then again, this question asks you, please also very briefly discuss if section 7 of the charter is applicable. Now, section 7 of the charter is right to life, liberty, and security. I'm sure you should know this by now. If you don't, then you're in trouble. Yes, section 7 over here. Again, you want to make sure that you talk about section 7 and see if this section is applicable in this scenario. I would think that it's not. But if you think otherwise, you should obviously argue that. Always remember that whenever you're arguing section 7, like I said, I don't think section 7 is applicable, but just because this question is a total of 100 marks. Okay, I don't know if it doesn't say here. Maybe it says somewhere up, but yeah, this question is 100 marks. So what I would do is I would talk about, I don't think section 7 is applicable. However, assuming that the courts find section 7 is applicable, we will then go on to section 1 analysis. Whenever you're asked about charter rights, always always go on to section 1 analysis. Always. If you don't have time, I mean, you could maybe state it very briefly, but always do that. So that's about that. And then so again, these are some of the basic issues that I would look for in a question on the exam. Again, I am talking about very basic issues, like procedure fairness in itself has a lot of other issues that you should be dealing with, like oral hearing. Then substantive issues, standard review, how to apply that standard. These are also issues that you should know. And again, you probably have notes by now, or you're reading the book, or whatever it is. You're gonna have to look all of that in there. But these are some of the things that I would consider right of appeal. Always look for right of appeal. This shows the examiner that, hey, you're able to, not just go to what you read, but your concepts are clear in terms of, you have to look back at the statute. So again, always look at the statute. So yeah, I think that this is the overall analysis that you should be looking for. If you have some other comments, feel free to let me know. If you are looking for sample question and answers, you can take a look at my website. I have actually written a detailed answer on this question. Again, this is my own work. So if you want additional help, feel free to check out my website.
That this was helpful. Again, I'm only providing a starting point and the way that I would answer this question. I think that after watching this video, you can definitely answer this question, or at least make some points that you can use answering a question like this. If you do need additional help, I have recently launched my website, which is lawstudykit.com, where I have drafted exam questions and then written detailed answers. So if you want to purchase any of that, you can definitely take a look at my website. The questions that I had mentioned in this video is the one that's on the admin sample question exam. If you are interested, you could take a look at it. If not, then again, I will be posting videos which will definitely give you a starting point in terms of working your way through these exams. Good luck. If you think this was helpful, you should give me a thumbs up and subscribe to my channel, because I'm going to be posting more content this week because I know that the exams are coming up. So I'll try my best to post as many videos as I can. So yeah, thank you for watching.